paid $30,000 for this whole new rebranding of the company and everything. And she was excited, and she showed me the logo that the branding company presented and that she was going to go forward with. And I was just like floored. I said, I'm sure don't they do a trademark search before, like as part of the branding process? No, not at all. I've had clients before that had been operating their business for years. And then somebody came in and, kind of made made their thousands of dollars, that then they're having to fight it. And then
Oh my
they
gosh.
needed to rebrand and all this kind of stuff.
I
But
think most business owners think that if you have an LLC that you registered, that it's a trademark, and it's not.
you may not know
setup.
that. And especially to protect
setup.
your friendship, make sure that you truly are on the same page. And if it just clarifies things immensely.
Okay, so Amber, you were telling us about a situation. What was that?
Without branding, without looking up trademarks.
Yeah, you had a story you
Yeah.
were telling us.
So I had this good friend that was an attorney and had legal services firm and was rebranding, paid $30,000 for this whole new rebranding of the company and everything. And she was excited, and she showed me the logo that the branding company presented and that she was going to go forward with. And I was just like floored. I said, I'm sure don't they do a trademark search before, like as part of the branding process? No, not at all. And I just was like shocked because there is no way that logo was not unique at all. There were a lot of other ones that were similar to it and could potentially have caused
Yeah.
like infringement issues. And
Oh,
it just kind of blew my mind that you could even have a branding company without that step. So anyways, it just really,
That's scary. I'm
it-
sorry.
yeah, it really surprised me.
scary.
But apparently that's like standard. It's not standard that they actually do a trademark search. And I mean, I per my experience and my research,
Really?
but I've never worked at a branding company. So,
Well,
but just
so you were asking the difference.
Yeah,
One
what's
of
the
y'all.
difference between a trademark, a copyright, and
a patent.
a patent?
Yeah.
So what's in the simplest terms?
So a trademark is protection that you have for an identifier for your company, or your person. It doesn't matter, but it can be like a name, a slogan, a logo, like all those type of things. That would be a trademark. Copyright is the type of protection you get over original creative works.
Mm.
So art, books, music, stuff like that. That's what a copyright would be. And then a patent is an intellectual property right over an invention.
Okay.
So they're three distinct things.
And that's typically like an invention, or like if I'm a scientist and I've discovered
Mhm.
invented something.
Yeah.
Or we are trying to do something and we discovered or invented something, that would be a
Right.
patent.
Yeah.
But artists are copyrights and all those kind of things.
Yeah.
So I'm a singer and all that.
So your
I try to-
music would
my
be
music would be
copyrighted, but you might have I mean, trademark in your name or likeness or something like that. Um, the types of different. So for a trademark, let me just use the example of Nike. There's the name Nike, so that could be a trademark. There's the swoosh, so their logo with the swoosh, that is a whole nother mark. And then there's the "Just Do It" slogan. That's something else that you can get a trademark on. Is a slogan like that.
Oh, so you see like the T and then you see the R.
Oh yeah, okay. So the TM
Uh-huh.
and then the R with the circle around it. The TM stands for, well, trademark, but indicates that someone is claiming their common law trademark rights. The R means that it's officially registered as a trademark, as a protected trademark with the United States Patent and Trademark Office.
So if someone is not trademarked, they're just running around here, they can just
They
put
can put
TM.
PM, and that's public notice. Hey, I'm claiming my
I'm claiming it.
I'm claiming my common law trademark rights. Yeah.
Wow.
So what's the process for trademarking and copywriting?
Okay, so you don't automatically have it. This is the interesting part that a lot of people don't know. Like a lot of people are like, "Oh, I have a trademark." I'm like, "No, we have filed a trademark application." That means that we filed an application with the USPTO, which is the United States Patent and Trademark Office. And the process is we file it, you pay their fees, you pay the attorney fees to file it, or you file it yourself, regardless. And then 6 to 9 months go by, and then finally it's assigned to a trademark attorney at the USPTO to review your application
Wow.
and to do a search and compare what you're trying to get an application, trying to register as a mark with everything else that's in the marketplace already. Um, and the phrase is whether there's a likelihood of confusion in the marketplace if your mark compared to somebody else's mark out there, if there's a likelihood of confusion. So, and that's kind of a vague discretionary standard, right? But so they would do a search and come back, and you get some kind of communication from the office, and it was called an office action. And they might say, "We found no conflicting marks, but you need to do this little administrative thing here or there, just like a minor something or another." Or they might say that they're rejecting your registration because of these, based on this mark and this one and this one. And then so after you get that communication, that office action, you need to review it, and either you can, if there were certain things like they wanted you to disclaim certain portions of it or whatnot, or you could argue against their rejection saying, well, no, there is no likelihood of confusion because of X, Y, or Z. um, there's a lot of things that they could say. That you could also be rejected if it's merely descriptive, or if the geographic terms in there, like if there's so her presence, if you had a registration of her presence, and then someone else is like her presence Oklahoma, well, that's just geographic. There's no difference there. But then you couldn't, it'd be really difficult to get well, you literally could not register a mark that said like, what's donuts, and you're a donut shop. Like you see all those, you see like, yeah, like just all the,
Yes.
or if that's what if they sell donuts, you're just like, that's merely descriptive. You're just selling donuts. So that's why there's like a billion donut places around, and they all just say donuts, or, some variation of that. But you wouldn't be able to get registration of that, is what I'm saying, if it's just a general word. So sometimes if you have some of those words in your proposed mark, you have to disclaim certain parts of them, or whatnot. Long story short, like a lot of people think that like, well, I get my trademark, or file the application, and then they have
It's
a
done.
registration, and they don't. It's like a while down the road, and then someone might oppose it. Um, and then if they oppose it, then you kind of, if you're gonna respond to their opposition and all this kind of stuff, then it turns into kind of like a litigation scenario with the USPTO has its own,
USPTO.
United States Patent Trademark Office.
Okay.
Yeah. So it's a big process, and it's the federal government, so it's not fast, right?
Right.
So we're talking maybe a year to
Yeah.
Year and a year and a half.
5 years, even 3
Yeah,
years.
I would say it's faster than that. Like you won't hear anything until about 6 to 9 months. And the trademark office fell quite behind during COVID, and I don't know if they ever really caught up.
Right.
But it's not a fast process. And another aspect of that is that there's 45 different, I think it's 45, somewhere close to that, different classifications. So you have to say what classification you're trying to get the mark
when you're
in
applying.
when you're applying. Yeah. So some of them are for services and some of them are goods based. Um, an example of why this is important, the word dove, right? That can indicate different things. So you have Dove soap and you have Dove chocolate. Different companies, different owners of the Dove, the word trademark Dove, but nobody is confused about it. There's no likelihood of confusion. You don't typically walk down the aisle at Walgreens and be like, "Oh, the chocolate company is now making soap." Like there's no, you aren't confused of the association or what it's indicating. But on another thing too is that it it's meant to, so you can have a mark in a classification like 35, which has to do like with if you're an online retail store or something like that. And it's just meant to indicate like that, to refer to your business, not necessarily the fact that this shot glass has your mark on it, or it's not like the goods, it's the services, like it references the store itself, not the specific items that are being sold. So it's a kind of a different way to think about it. um but then some other really prolific um names like Nike or things like that, it might indicate like shoes. I love some, or I used to run a lot, and the shoes, I really liked Nike shoes for a period of time. And so it was like technically the shoes, not the company, that it was like their actual shoes I liked. So, but that mark in general is just like nobody could probably register anything close to Nike in any mark because it is so
Yeah.
so wide. But
So do you have to renew? Do your
that's a
trademark?
really great question.
Okay.
You have, after you get registered, you have maintenance fees. So often you have like 5 to 6 years or whatever, you have to pay maintenance fees to kind of for the next 5 years. And
Maintenance for
even
what?
to continue having the protection of the USPTO, I guess. So if you have, that's a good question. I never really thought of it quite like that. But once you have it, so intellectual property rights in general are different than, it's a unique area of law. It's fun. I like it.
I see your passion over here.
It's just interesting. It doesn't give you the right to do something. It's not like I don't know, some legal things you go and you get some permit that allows you to go do this. It's flipped. What it allows you to do is prohibit others from doing something. So innate in that dynamic is that you have to actively protect your mark in order for it to have any value. So you can't just let everybody use it and then all of a sudden complain and try to prevent others. Then you have to actively, as it goes along, protect it.
Gotcha.
Yeah. So
Wow.
So let's say that someone's going around with the TM and another person, same, looks identical and has registered and has gotten approval and everything. Then is that across the board? That's all states?
yes.
Okay.
Okay. Yeah.
So they're registered and someone's going around with, you know, um, I don't know, some name, ABC, whatever, of Oklahoma. You can ask them to stop using it.
you can send a cease and desist, and yeah, to try to get them to stop using it. That does that is challenging. Like the ability to effectively enforce your marks and stuff is a whole nother issue. But having the registration gives you a prima facie, which means like on its face a better
Mm.
superior right to use the mark than somebody else. But if push came to shove and you're in litigation and this and that person can prove they've been using it actively for much longer than the other person that actually has the registration. So once you get a registered mark, it's not even guaranteed that you can prevent everyone else from using it. It's very fact specific.
Oh my
So
gosh. Been using this longer than you've been born, and
yeah,
here you
but
go.
but it's if you really have a unique name that you're trying to use or a logo or that type of thing, then I do still recommend that you get the registration because it really would help if someone else tried to prevent you from
Mhm.
using it.
Mhm.
I've had clients before that had been operating their business for years, and then somebody came in and kind of made made their thousands of dollars, that then they're having to fight it, and then
Oh my
they
gosh.
needed to rebrand and all this kind of stuff, and it was really that was a difficult conversation because she's like, okay, so I didn't do this step before, so okay, now I want how much do I pay to get this trademark, and when do I have it? And I was like, well, we can file the application for it, but I can't guarantee, there's zero guarantee that you're ever going to get it.
Mm.
So, anyway, she was
Yeah.
not happy with the scenario, but that's just the way it is.
Yeah.
I
But
think most business owners think that if you have an LLC that you registered, that it's a trademark, and it's not.
that's a very good point. A
It's
lot of
not.
people, what you have with the Secretary of State, what name you pick, it has literally nothing to do with a trademark. It's a totally different.
Yep.
You can still you can have an be registered with the Secretary of State, have your name and everything, and if you use it in the marketplace, it could infringe on somebody else's trademark, depending what your name is and how you're using it. So
So how does a company prevent all of that in the beginning? If you're starting up, what is one of the first things you need to do to ensure is how would you do that? Start that search. What would you do?
it really depends on what type of company it is,
Mhm.
because so I had this other client who she had been operating, it was a hair salon type business, and she'd been operating it in the hill country in New Braunfels for 10, 12 years. She did hair for weddings and things like that, and she got a cease and desist from some girl that had some kind of a hair salon in the Philadelphia area.
Mm.
So, and there actually was some, not even a likelihood of confusion in the marketplace. There was actual confusion because their emails,
Mm.
their websites looked very similar to each other. And so there were some people that just pull up the website. And I mean, honestly, if they looked closer, they could tell one's on the literally like what 1,500 miles away, like that it was the wrong one, but they looked and seemed so similar. um but on the flip side, because they were so different, she received a cease and desist, and we responded and we tried to negotiate and be like, okay, well, I'll do this, and then it came down to it, and it was like the we didn't stop using it, and whether in part because we knew this salon owner was not going to actually sue her.
Mm,
You'd figured that out.
Yeah.
yeah.
Yeah. And what is the likelihood that she would actually win? There was,
That
because it's so far away, the physical location is so far away.
Right.
The name was not like, I mean, it was different. It was similar. Their name was very, very, very similar to each other. Um, Actually, it was identical, to be honest. But how many hair salons are there? You know what I'm saying?
Yeah.
Just because
And
of
the likelihood.
that type of a business, and the fact that it's mostly local, and just the specific details of
That's crazy. I
case.
wonder what happened. Like, were they booking? People were paying money, and no, I never got it. Then you find out, oh, it's going over here, Texas, this Texas place.
Mhm.
I wonder. Wow.
There was confusion in the emails and stuff like that, and um, it just came down to where I think eventually the other party just changed their name or their email. But they actually had the registration, but my client had been using it years longer.
Mm.
Um, and yeah, but so a little bit,
Okay.
it depends on the
Wow.
type of business, right? The
Mhm.
level of um just in general, the type of business.
Yeah.
Mm.
You really have to, when you do your branding, you really have to go in with your eyes wide open, do all the research, see if there is a possibility that once you spend this money, this time, and registering, that it's going to be worth it. Like, what is the likelihood of someone,
Hmm.
you know?
Is there anything out there already? Some like super unique, cool name? Well,
Mhm.
so my recommendation when you're looking at stuff like that, do a Google search or,
Mhm.
like that type of a thing. Do it on some variations of your name. Don't just put the one thing in. And sometimes your searches are limited depending on the search engine, they're limited geographically. So maybe you're
Mhm.
not pulling up everything in the country.
Mhm.
But, do a deep dive in that direction, but also on the USPTO website, which is just www.uspto.gov. When you go there, it there you can select the trademark tab or whatever, and just do a search. And their search engine is really simple.
Mm.
It has like a Boolean search. You can do a more advanced one, but you can just put
Mm.
in some main names there and see what comes up and see if something's already out there. Um, I don't know. I kind of like go back and forth in my head and what the actual recommendation would be of like what are the steps should you take first,
Mhm.
because if you pay thousands of dollars and try to get multiple different trademarks and try to do that first, and you're not even guaranteed for that, but a lot of that you'll get it, but a lot of companies don't have thousands of dollars when they're starting
Mhm.
out.
We're starting.
So that's very um
Kind of risky.
Yeah.
yes, it's
Mhm.
risky. But then I do recommend once you have your feet on the ground and you're kind of then you revisit it.
Hmm.
Mm.
Hmm.
And if you're trying to do this registration your own self, uh, you'll be surprised about how many things you'll probably miss or not understand. I know one of the a couple of the things you talked about was 30, there's 30,
I think it's 45.
oh, 45 different
It's 45.
types or
Mm-hmm.
areas or
Classifications, yeah.
classifications.
Mm.
When I mean, you definitely could do it, but then there's,
And some of that stuff you can't change. Um
once
that
you've done it.
meaning, yeah, once you file, yeah, there is 45 distinct categories. I knew I was right. And I should
Okay.
have
And can yours be in many different
Yes,
categories?
as long as you're actually operating in that category, because you
Mhm.
have to, as part of it, you either file it as in use or intent to use.
Mm.
And if it's in use, and even intent to use later on, you have to submit what's called a statement of use and a specimen showing your actual use of it in the marketplace. Like if it's the example I said, like some kind of online retail or
Mhm.
something, some kind of Etsy related account, then you'd have to
Mm.
show like a screenshot of the
Mm.
website showing
Nice.
you actually using it in commerce. But
Mhm.
you have to be able to show the use of it in, and there's different ways and requirements of how to show the use in the different marks.
Gotcha.
You can't just show like a bottle of something on a website if the bottle itself maybe doesn't have the mark on it, or things like that. So anyways, it
Mm.
it it gets tricky. And so you have in use, you have intent to use, but certain things for the trademark applications you can't change. Like you can't, if you're like, oh, I put classification 17, and some of them are like there's coordinating classes where they work together or they're similar, and
Mm.
depending exactly how you're using it, it might be both or it might just be one. And but if you choose the wrong one, you can't just amend it and change it. You have to refile from the beginning.
Oh, wow.
So there
Mm.
is a significant risk in doing it on your own.
Mm.
You can't also, if it gets rejected, you can't change a logo. You can't change the way it looks. You have to restart again.
Mhm.
So if you do look at doing it on your own, you got to do a good amount of research because it's just really easy to And
That's
the
it.
USPTO fees it's 300 currently, and they're subject to change, right? It's $350 per mark per class right now.
Wow.
Per
So if
mark.
you got
Per
5,
class,
Yeah.
okay, that
how
tells you.
can we do 2?
Yeah.
Just 1.
Yeah.
Okay. So, okay, tell us about you and your law firm.
Oh, okay.
Yeah.
Yeah. So I've been an attorney over 16 years. I started my practice in the intellectual property area, so which is probably why I think I find it exciting. I think it's fun. But so um, I'm a registered patent attorney, and so that's where I started. And the on the prosecution, I'm a patent prosecution attorney, so that means like drafting and prosecuting the application. So everything from submitting the application until it issues as a patent. Anything, so that's called prosecution, which is sort of a funny name. um, can be confusing to people because it sounds like litigation, but it sounds like it would be litigation, but it's not. It's just the process of getting a registered
Mhm.
getting an issued patent. Excuse me. Anything like if there was a problem with infringement, I do a lot of pre-litigation stuff too, like freedom to operate agreements and some of that type of work. But if it's litigation, you're being sued, that's when I call in some of my litigation attorney friends. But
Mm.
anyways, I focused exclusively on patent prosecution for a number of years, and then I started my own firm when I was trying to raise our 4 kids at the same time. So I started my own firm, and then got into some more of the trademark and contract negotiation type situations, a lot of business formation. Um, and then I, about 5 years ago, started incorporating estate planning into my practice,
Mm.
and which a lot of people think is just like super different. It is different, certainly, but many individuals have their own LLCs or businesses, and being able to link their interest in their business with their estate plans and talk about business succession is another big thing. Meaning like what happens when I get too old? What about my company? Do I want it to go to my kids? Do I
Mhm.
want it to go to a partner that I've been working with? Like all that. um it's it's a lot of things that people don't think of. Some really successful business owners and everything, they sort of have their business, and they may or may not have an estate plan, but they a lot of them don't think about linking them. A lot of people that have LLCs and they have properties in maybe owned by the LLC. Well, what happens if they die? If there's then that whole all those properties are not legally associated with their spouse, maybe, or their family, if they're the only person that was associated with the LLC. I don't know. It gets really,
Yeah,
Oh,
yeah.
yeah.
yeah, it gets
Goodness.
Wow.
really
Yes.
interesting. So
And the name of the law firm?
Davideck Law Firm. We're rebranding to Texas Asset Protection Law, but we're in New
New
Braunfels.
Braunfels.
Yeah.
Okay.
So
Right down the road.
yep.
Right down the road.
Yep, not too far away. But
So, I was making sure you didn't go ahead.
What's a non-disclosure?
oh, that's a
And
great.
are there is there another disclosure as well if you're partnering with someone?
There's a bunch of
Oh,
different type of disclosures. Like so I'm NDAs is what non-disclosure agreement. There are different types of NDAs. There's a one-way NDA or a two-way, depending who's the one releasing information
Oh,
or and who's the disclosing
oh, got
party and
it.
who's the
Mhm,
receiving
mhm,
party, or if
mhm.
it's
Makes
like
sense.
mutual.
yeah.
But NDAs are really important if especially as it relates to intellectual property rights. You want to make sure that you're protecting the not only your IP rights, but confidentiality of, and that's critical when depending what you're sharing with these other people. If you're talking about entering into any type of a contract, then you should have an NDA in place before you get into in-depth discussions, because then you're if you're the one trying to hire, or I don't, even if it's just a supplier, um, they are going to be privy to like how your company works, your business processes, that like some other things that are very valuable to you.
Mhm.
And so, and yeah, Non-disclosure agreements are very important.
What's the life on those? Is it forever? Is it?
It depends on
Mhm.
what is specified in the contract.
Mhm.
Most of the time, there's some type of a term for it. But then the confidentiality obligations, some of those go for a certain number of years after the end of the period of engagement. Like if you were thinking about merging with this company and then you decided not to, they're still obligated to keep everything they learned confidential for certain periods of time.
Mhm.
As it relates to intellectual property, it might be forever, or they might not have a set term, but it depends on what aspect of the information that was shared
Mm.
and what the contract itself says.
So you have a question? Go.
This is my
You're like,
spot. I'm so glad she's here. So what? I'm sorry, y'all. Forgive
Go.
me. Yeah,
No,
okay.
no, we-
So what is the
please.
first IP that a entrepreneur or small business should protect when they first launch? Would you think?
Guess it depends on what
It depends on the type of
the
company
type
and
of
what they are.
business.
I've worked with a lot of startups. I
Mhm.
was kind of synced with a or partnered with a investment venture capitalist group that had all these different groups of groups of portfolio companies that they would invest in and all this kind of stuff. And I would meet with them and talk about business formation, intellectual property rights, all that kind of stuff. Now, while we talked a decent amount about trademarks and how important they are and how they can help you, um, patent rights are, if your whole company is based around this certain, you know, uh, medical robot or something, then for that company, who cares what they're called? Probably what's most important is that their patent, they have
Yes.
patent protection on the device
Yeah.
itself.
Yeah.
So it really totally depends. Um,
Good point.
yeah, so
Good
for
point.
something like that, it might be it's really more of a patent important thing. If it's some other companies, it might be a trademark because they need a unique name, or if it has to do with an author, it would
Mm.
be a copyright. It could for their creative works. The so it really kind of just depends. I'm sorry, that's like my go-to answer for everything.
Because I
Yeah,
guess
it's a-
I mean,
it's
it
a
has
good
to
one.
be
It's a
case to
good one.
case.
No, it's a good
Yeah,
one. It's
absolutely.
very
It's
accurate.
really not a.
Yeah.
Yeah.
There's a lot.
Various
Most
scenarios.
things with
Yeah.
the areas of law that I've worked in, and law in general, I believe it just depends on the situation.
Mm.
Yeah,
So
makes sense.
we have different types of businesses.
Yeah.
The LLCs, S Corp, C Corp, sole proprietor. All these.
So let
Go.
me jump in there.
Okay.
So you're saying
Thank you.
LLC, S Corp. S Corp is actually a tax filing. So for an LLC, it can be taxed as a disregarded entity. So you just, in your own personal taxes is kind of like
One
it's
member
just in line.
kind of.
Exactly.
Mm-hmm.
It can be taxed as a partnership. It can be taxed as a corporation, and it can be taxed as an S Corp. So all of those are ways an LLC
LLC can be.
can be
Mhm.
taxed.
So one is the way the IRS, federal government looks at you or
Exactly.
tax, and the
Mhm.
other one
And
is
one has to do
typically
with,
the
like,
state or
legal-
whatever,
yeah,
local
legal
or legal
protection.
protection.
Um, and one thing that I do a lot that's been really fun is helping. Like I have a number of clients that I've done estate plans for, and they might own a ranch, and then on the ranch they also have this other business, but then they have cattle, but then they have this. So like
They
and
rent out I have a client that
Equipment.
he's renting out he has a ranch, but then he's also renting out
oh
some of
yeah,
the cattle. So that's a whole nother business.
yeah.
Renting
So
out cattle.
He's renting out some of these
Wow.
sheep or whatever it is.
so leasing.
Okay.
So maybe
He's leasing
property
out. Sorry,
from
not renting, but
owner.
leasing out. Uh-huh.
But it's important to structure the companies for liability purposes. Like you might have an LLC over that is just the cattle. Then you have an LLC that this is this land. So if there's an accident with the cattle, the only thing at issue is the cattle, not the land, because they're
Mhm.
leasing the land from another. There's a lot of strategic um, business organization to really comprehensively protect you and your family. And
Mhm.
that's that's actually really fun because then you just have to talk to the clients and get the specifics of, okay, well, do they always be over here or do they graze elsewhere? Do they, I mean, just
Mhm.
talking about that one particular thing, but and then just thinking high level, what are the risks,
Mhm.
and trying to minimize risk to them from a legal perspective, but still set it up in a way that is beneficial tax wise, so you can have like create another LLC that's sort of essentially a holding company, and these other that is the managing partner of these other LLCs, so that they and this LLC does nothing except for manages these companies so that you only have one tax filing.
What
So
does Series LLC mean?
ooh, that's a fun one. So
Sorry, everyone.
Let me get my pen.
Go back and
so
watch
with
this.
it's not all states allow them, but
Mhm.
Texas does, and I think it's great. If you have 7 rental properties, you could do 7 separate LLCs, right? But that's a lot of cost and everything. A series LLC is essentially you have almost like a holding company. You have the master LLC here, and then Series A
Yes.
owns or whatever property A. Series
Mhm.
B owns property B. Like, so you could have multiple different series. Actually, I have a client that I think we have A through M, like it's so many different
Mhm.
ones. And if you properly handle the separate series, then meaning keep them separate, like separate bank accounts, separate, like all that kind of stuff, no commingling of
Yes.
the
Mhm.
accounts, then it limits the liability to that one property.
Because if
Mhm.
someone
So,
goes after L,
It's
then they
only
can
after
actually go after A, B, C, and D because it's been
mingled.
co-mingled.
if you commingle it, yeah.
Mhm.
But if you structure it properly, almost like its own separate LLC is the way it needs to be, then you can limit the liability just to that. And certainly, you never commingle with your family funds, your individual
Yes,
personal
because
funds.
now you're in trouble.
Yeah.
Okay, so you have the you have the Series LLC, um, and you say A is this, B, but that could be a name, or is it an actual
I
the
mean, you can
series name
do
and then
some kind
A,
of do an assumed name for it if you want,
but
but
it's still under that.
mhm,
If it's already an LLC in place and it was not a series,
you can convert
you
it.
can convert it to
Mhm.
series.
Yes, you can.
Mhm.
Yeah, you can do that on the Secretary of State website. Um, a lot of really, I know we mentioned this already, but the critical part of it is though just the handling of it separately. I mean, so many
Critical.
people might get things organized and then just not follow through with how they should be, and it does, and it if you break that separation, then that's how they pierce the corporate veil, and they can include the assets
Yeah.
of multiple different what should be separate series or separate.
Is it, and I know you're probably, well, I don't know. I don't know how you're gonna answer this. LLC, so we have an investment, a real estate investment asset here, and should we do an LLC or should we do a trust? And does it matter? Does it go together? Is one within the other? I don't know. Because I've heard people say, well, like ask me, should I get a trust or should I get an LLC? And I'm like, what? We're just gonna do an LLC. But I don't
Well, okay, there are multiple different types of trusts. So that's one thing. There are also
for
um,
real estate for their investment, I'm sorry, their business investment real estate that they're going to be using for rentals, or probably they're going to hold and rent out.
so what we see most of is that it's an LLC, and then it is linked through their operating agreement. The interest in that LLC is linked to like a family trust or something like that. but you can have. I had a client yesterday that there's basically, so it depends what state too, is kind of where I'm going with this. She has, there's a property in Michigan that her mom had put into a trust where it's an irrevocable trust. I don't recall if it was initially an irrevocable trust or if it became irrevocable upon her death. If it was prior to that, if it was more of like a living trust, I don't recall exactly. But now that property and the funds that were that are included in that trust, that just allows this property to be maintained, and then her and her siblings go there and visit each other. So it's like kind of set in this trust scenario.
Sweet.
So yeah, it's really nice.
Yeah.
Um, so that's so it might have been because I don't know the details of exactly what type of trust it was, but
It might have been just they were they you know how people pick up things, so maybe it's both is to protect, but one is for things such as what you just said. I'm protecting it from a family point of view, or if something happens to me, it's protected, so that it doesn't have to go through probate or whatever the
Mhm.
case may
Yeah.
be. And then LLC is also a protection, but from a business point of view, you're protecting your assets. Maybe
Yeah.
I always wonder about that. Like, down through the years, people will say that. I'm like, but I'm always thinking from a business point of view. So I always wondered, where did trust come in with that? And I wonder if that's what it is. I mean, I know.
Yeah, there's a lot of other, like, some family limited partnerships and stuff, and they have different business entities associated with those, or they have some kind of an irrevocable trust that includes this property.
Mm,
There's so much
different things.
interrelation through all this, and there's a some of it can get very complex, and a lot of times people are not using the proper word, or they might just say trust, but you don't know exactly what kind of trust, what. So
Makes sense.
it
Really
does
does.
make this area kind of confusing. It can be for anybody. A lot of times people come in and they say, I have this, and I have to, like, okay, well, what is it? Like,
Tell me more about
how does
it.
this work? Like, where, because, and then it's like, okay, I understand what you're saying. You're using not the correct word per se, but um, so anyways,
Yeah.
it's kind of interesting.
Okay.
But
Any questions? I have another
How
one.
does a business owner or someone starting up get in consultation with you?
to call our front desk
Just
and
call them.
schedule it. Yeah,
Okay.
the we do our estate planning consultations after people fill out the intake form and everything. It's a 2-hour block where we're not paid if they don't engage.
Mhm.
So it's a free 2-hour whatever, but it's
2 hours of education.
it is. That's exactly what it is. For a business scenario, either typically it's like a 15-minute phone call, again, free.
Mhm.
Um, and I talked to a lady yesterday, really sweet, and she's starting out her business. She has a logo she's excited about, this and that, but hasn't registered it with the Secretary of State. Really just didn't know where to start. I talked to her for 30 minutes, and she might circle back in a year
Ready.
when she's ready.
Mhm.
But so at least a 15-minute phone call would be a good place to start to see if somebody's ready or where they are, to gauge where they are. Um, but not all firms do that, but it's kind of, I think it's great when someone does, because you don't know what you don't know, and you don't necessarily know where to start. And yeah, so
Yeah, I think it definitely for us, it uncovered a bunch of other things that we needed help in, that we did not know that we needed help in.
mhm.
So,
So, with new businesses, I'm trying not to laugh at this one. Um, People want to say that a good handshake is great for conducting business. When would you want to do a handshake versus a written contract?
I don't know. If I was a good old boy man from the 1950s, I might do a handshake, but I would never do that now. I think everything should be in writing, and it should be, I mean, especially, especially when it's a lot of people like, well, we're good friends. We're on the same page. This
Mhm.
you may
It's a
not know
setup.
that. And especially to
It's a
protect
setup.
your friendship, make sure that
Mhm.
you truly are on the same page. And if it just clarifies things immensely.
I think that is so good to protect the friendship
Yeah.
or even the family. What
Honor.
we've been talking about, like even with the previous episode, these things are set to protect
The relationship
the relationship.
Yes.
between your
Yes.
children, between
Mhm.
um
Friends.
yeah, between exactly
Families.
between
Yeah.
the I mean I've seen
Respect.
so many situations where siblings or friends, they think they're on the same page, and maybe they are on some points, but the things they don't think to talk about, they're not on the same page with. And then inevitably somebody feels like they put more into it than the other person and blah blah blah, and then it ends up a mess.
Yeah.
Right.
So I don't
Right.
think a handshake is a great idea unless like if it's after you sign something. I think
Oh, I thought you were gonna say unless it's like, I was
no,
like, wait,
no, like after you're done.
like, let's handshake. Give you a little hug.
Yeah, exactly.
Yeah.
It's just not.
It's funny you bring up contracts. So I can look on AI, get a
Mhm.
contract. We talked about this.
Yeah.
So you had a story.
Oh my gosh. And the AI is great. I mean, I use it, and the but it only gives you feedback based on your prompt that you put in. And a non-attorney doesn't necessarily know what to put in to get the correct feedback. But I had I was kind of outside general counsel for this one company for a while, and it was really fun. I did drafted and got patents like issued for them and stuff, and it was a neat thing. But anyways, the after there was this other agreement we were trying to put in place for me with them for consultation or attorney work or whatever. And so I provided them with a draft agreement, and they came back with it like redlined well, and it had an indemnification provision, meaning like if I cause something, then I indemnify you. And on that one, I don't know. It just they had a whole bunch of notes on it and stuff that were totally irrelevant. Had to do with like a supplier type of agreement rather than like legal services. And then on the indemnification provision, it was like this really needs to be two-sided, this and that. We can have someone look at, or we can have another attorney look at it, or would you just agree to like reciprocal indemnification? I just laughed because I was like, okay, so you're saying it needs to be in here that you indemnify me? Okay, like it just so like they were like the opinion was, I mean, because otherwise that's saying you owe me money. Like it was not there. It was the draft that I provided them did not, because the within the scope of work, there wasn't a scenario where it was appropriate for them to have to indemnify me for anything because they weren't going to do anything that would have harmed me.
Mhm.
But, they ran it through AI and they came back and saying, it really should be two-sided. And I was like, okay, this like it was kind of laughable.
Well, now.
So
Okay. Pulling these contracts off AI.
yeah.
Okay, so we actually have about, can you believe it, 2 or 3 more minutes.
Oh my goodness.
So Goodwill.
Goodwill in a
Yes.
contract?
So, okay, so my understanding of goodwill is you actually, and we talked about this also, not in a contract, just goodwill when, as far as an intangible asset.
Mhm.
Um, and it usually doesn't come about until you're about to, or until you sell, or there's a transaction of selling, right?
Yeah.
But do you guys deal with, or what's your thoughts on goodwill
It
and
is
how to,
it is
yeah.
an intangible asset, right? And in some ways it can be quantified, but not always. And
Mhm.
it's really challenging. I've done a number of agreements, business sales. One that was based, it was primarily the goodwill that my client was purchasing. The tricky part about that is, though, if you're selling, the goodwill and your contacts, your customer contacts and all this, you have to, how do you know that that other person who was selling their goodwill is going to follow through on
Mhm.
that side? There's tax implications on how you structure the agreement. That's another thing. If there are tangible assets that go along with the goodwill, they can be really tricky. Um, there is no way you should ever do that without a written agreement and attorney consultation.
Yeah,
Because if
because
you're
of the
agreeing to
value.
any, yeah. Um, so those that is it was one of the more challenging contracts to put together. Like everybody, the parties kind of agreed on the terms and stuff, but then having to put in the um what's the word, the benchmarks of
Mhm.
how do you know when this has been fulfilled, when if the other person was required to turn over a contact list and
Mhm. Mhm.
to not act in a certain way that is going to then damage the goodwill that you
Yeah,
are paying for, and
that
that can be
value.
really challenging.
So, okay, so I'm gonna make sure I understand or that we put out what goodwill. So, all of my tangible things have a value, right? And even the
Which
list.
you can get a fair market value for, right? Like
Mm-hmm.
how much did you buy the piece of machinery for? How much could you sell it for now? What
Mhm.
the depreciation, like some of that is a lot more set, right?
Right. That's like, okay, we can find that. There's not a lot of gray area, right?
Right. Hmm.
And then my list of people starts going into this because it has a value. It goes into this
Yeah. So if you're for goodwill, a lot of times, or in some of the circumstances,
a list of
you're
clients.
paying for the relationship. So and the fact, like not just the customer list, but them saying you should use this person. Like this is so
You're a
that.
household brand, a household name.
A lot of times, if you're buying someone's goodwill, then they're not going to use it anymore, so they can't operate in that space anymore. I mean,
Mhm.
there could be scenarios where you agree that they can or whatever, but for the most part, if you're buying someone's goodwill, they're not also using it at the same
Mhm,
time.
mhm.
Basically, maybe they're retiring or they're just going into a different field or whatever. But part of buying the goodwill a lot of times is buying their relationship with clients or customers, that the list of which they're turning over or whatever. But also you could buy someone's goodwill and then maybe they go out and do something crazy and that damages the value
Mhm.
of what their goodwill was, if it's some really public thing. So
That's
those
crazy.
those agreements can be challenging.
Mm.
You're connected to the goodwill because they're a part of the brand. Their face is the branding
Hmm.
of that.
Exactly.
So anything they do after the fact,
Hmm.
then there's like, if you do damage it, then you owe me money too. I need that in the contract now.
Yeah.
Mhm.
In writing. Yeah.
So we talked about contracts a little bit earlier before we don't do the handshake, but we have a contract. How often or when should I hire an attorney to view a contract for me? And what are if I don't have um, the money to have
Mhm.
one on my team, what are ways that I can acquire an attorney?
A lot of times I'll draft templates for different people, that more on kind of a project basis. Like, okay, there's this one client I had that recently, that she's going to be hiring a bunch of nurse practitioners to, or PAs or something like that, to work under her. So I drafted up like a customized agreement for her to be able to do that. That type of scenario. um, if you're doing going to be hiring a whole bunch of people,
Hmm.
that you have a lot of different levels and different types of obligations to them, as well as, so in those scenarios, getting some templates for in the
Hmm.
beginning, on you could do that on a project basis. That's a great idea. Another recommendation is, if you're entering into a contract for a certain work, there's a client I have that does like architectural type projects, CAD related, something like that. And he was asked to, well, he's trying to get to win this project, this
Mhm.
bid,
Mhm.
$100,000 project or something
Mhm.
like that. And they have attorneys on their side. Get your own attorney.
Mhm.
Yeah.
Mhm.
So
Yeah.
I definitely recommend that.
Okay.
Well, thank
Those
you.
two scenarios.
And are there options for me to obtain an attorney? Retainer?
Retainer, you can do it on project basis. You can, I mean, it depends. It's up to the attorney and the firm how they
Gotcha.
operate. But I do project basis. We could do hourly. We could, but it's good to
Mhm.
have an attorney contact, certainly.
And then we get that relationship, that goodwill.
Yes.
Mhm.
It's different.
There you go.
Know your business, and they're able to also provide you good information.
Sure. Yeah.
Okay. Man, this could go on forever. We could
It
keep
could.
talking. Wow. Okay. So, any one thing that's a takeaway for our listeners, anything that has to do with patents or trademarks or goodwill, copyrights or
Contracts.
contracts,
Obtaining-
AI,
Obtaining an attorney.
obtaining an attorney, anything, any takeaway.
For big, yes, I would say like for big contracts or big engagements for your company, seek an attorney. Don't rely solely on AI. Definitely don't rely solely on that. You don't necessarily have to go pay an attorney to set up your LLC, get the operating agreement and everything, like before you even know if you have a business. Try to figure out that first, and then at the soonest possibility, then I would say seek out a good attorney and get some legal expertise.
That's good. Sounds good. Well, thank you for joining us. Thank you guys for coming and listening to Her Presence. Please make sure that you share, like, subscribe. We are on YouTube. We are also on Spotify, all the major platforms, social media platforms, and the podcast platforms. And make sure you join us next time. Thank you again.